Peut-être quelques mots en français pour commencer, après on va basculer en anglais. Donc je suis Simon Wesley, je suis avocat au barreau de Lyon, mais à l'origine j'étais solliciteur England and Wales. J'ai commencé ma carrière à Londres il y a très longtemps. J'ai passé quelques années en Angleterre et puis je suis venu à Paris où j'ai travaillé pour un cabinet international britannique avant de venir sur Lyon il y a 20 ans. Et je partage mes activités entre le cabinet, je travaille pour un cabinet lyonnais et la faculté. Mon activité professionnelle, c'est plutôt le droit des affaires, les contrats internationaux et le contentieux. Donc j'insiste beaucoup sur les questions. On va aller cette année assez lentement pour que vous puissiez prendre des notes. Si vous avez le moindre problème, il faut le dire. Il ne faut pas être, shy ou réticent à poser des questions. Je pense que si vous posez une question, au moins 50% de vos collègues n'auront même pas pensé à la question et encore moins à la réponse. Donc, les questions rendent toujours service et quand vous êtes avocat plus tard, beaucoup de notre activité consiste à poser des questions. Et souvent, on pose les mauvaises questions au départ. C'est pas grave, parce qu'en posant les questions, petit à petit, on arrive à la bonne question et puis, avec un peu de chance, la bonne réponse. Donc, il ne faut pas avoir peur de poser une question qui semble peut-être un peu idiote, ça ne fait rien. Ça fait partie de l'activité. La deuxième chose que je voulais vous dire, c'est que il n'y a pas de plan à la française. Et je sais que chaque année, les étudiants sont un peu déboussolés. Ils ont leur couleur toute prête pour marquer la grande partie 1, petit 1, etc. Ça ne viendrait pas comme ça. Par moment, peut-être oui, avec un peu de chance. Donc, il ne faut pas s'attendre à un cours très structuré. Vous aurez un plan avec des parties. Je n'ai jamais réussi à le faire, malgré une présence en France depuis longtemps. Si vous allez dans une université anglo-saxonne, vous allez découvrir qu'il n'y a pas vraiment de plan non plus dans les cours. Donc ce que vous faites avec moi, c'est un peu la préparation pour votre année Erasmus ou dans une université à l'étranger. Donc ce qu'il faut essayer de faire, c'est ne pas nécessairement noter chaque mot, mais essayer de capter l'essentiel. Et si vous souhaitez que je revienne sur un point, il faut poser la question et on le fera. En anglais ou en français. Si vraiment il y avait un problème de compréhension, il faut le dire et on peut le faire comme ça. Est-ce qu'il y a des questions là-dessus? En termes d'organisation, on commence si possible à midi. Parfois il y a un petit décalage parce que le prof finit un peu tard. On s'arrête vers 1h pour prendre 10 minutes de pause. Ça vous permet de manger un sandwich. Et puis nous terminerons vers 2h moins le quart, 2h moins 10. Et si vous voyez le temps passer et que je ne m'arrête pas, il faut m'arrêter. Comme ça vous permet d'aller tranquillement à votre cours suivant. Pardon, j'ai perdu le micro. Vous m'entendez toujours? Okay. So, now in English. The first question is, why would you want to study English law? Well, I suppose the first question, or the first answer to that is that if you're at a comparative law institute, you want to just compare the French system with another legal system, and you couldn't you couldn't choose a legal system that is more different. As you will discover, there's very little that is similar between the two systems. The second reason might be that you want to improve your knowledge of English legal vocabulary. Also to learn about English legal and business culture. More concretely, perhaps, to prepare an Erasmus exchange. And you will find, of course, that if you go to study in England, whether it's in England, Northern Ireland, Scotland, Ireland, or Australia, or America, North or South, you will find that, or in Hong Kong, Australia, Singapore, wherever it is, we all share this common law system. So a system which originated in England is now in use in a very large number of countries across the American continent, or Africa and Asia. So wherever you find yourselves later, you will probably find that it's useful. I was at a wedding in Burgundy this weekend, and quite by chance met one of your predecessors. And I asked her, well, what are you doing now? She's working for a law firm in Paris, which is a joint venture between a Chinese firm, a British firm, a French firm, another firm. And she is specialized in corporate finance, and they get involved in international corporate finance. So you never quite know where English law will take you. I had another student who ended up doing aircraft leases in Japan, also for a big English firm. So those are perhaps a few reasons why you might want to study English law. What we're going to do today, more precisely, is just to have a general introduction to the system, and I'll try and take you through the background to the English Constitution, the sources of law. First of all, just a few introductory remarks. Why is the English system original? Well, one of the first originalities is the variety of the sources of law. That's something we'll look at quite quickly today, and then in much more detail in the coming weeks. The second originality of the system is the way it's developed, and the legal method. A third originality is the constitutional organization of the United Kingdom. And we will also find that the system of procedure in common law countries is original in the sense that it is different to the French system. So already you have almost at every level in the legal system some quite significant differences. And my objective, or our objective together, is to try and establish a basis of information and understanding of this original system, and then progress, to enable you to progress into specialty areas and international legal careers later. The first thing perhaps that you need to note down is that the United Kingdom does not have a single legal system. We'll see in a moment that there's a distinction between England and Wales, And I am a solicitor, I was a solicitor of England and Wales. So there's a difference between England and Wales, and then Northern Ireland and Scotland, which have different systems, even though they're quite close to the system of law in England and Wales. We'll also see that constitutionally, the arrangements for Scotland and Northern Ireland are different, and also for Wales to some extent. So, as a French lawyer, where you're looking for organization, coherence, structure, you won't find it. Don't look for it. Leave your French lawyer's reflexes behind. Just take it as it comes. Because if you try to build it into some kind of coherent framework, you won't succeed. So I said, first of all, variety of sources. And in order to understand the variety of sources of English law, you have to know that it includes ancient laws and customs that came from the period before William of Normandy invaded England in 1066. So that part of our law, even today, although it's not very apparent, comes from laws and customs that came from the Anglo-Saxon countries, Denmark, north of Germany, Scandinavia. And then William of Normandy invaded England in 1066 and conquered the south of England and brought with him parts of Norman feudal law. And if you look at, for example, English land law, even today it is still very strongly influenced or inspired by Norman feudal land law. When William invaded England, he came to an agreement with the local aristocracy, or at least that part of the aristocracy that wanted to do business with him, that he would preserve the laws and customs of England. And that is fundamental. We'll come back to that. This promise of the monarch to guarantee, to preserve the laws and customs of England. Each king and queen of England make that promise when they accede to the throne. So our current monarch, Elizabeth II, made that promise in 1953. And we'll see it's an important reason why we are attached to the monarchy. Because the monarchy plays a central constitutional role guaranteeing continuity of the legal system. And that promise, of course, is a promise that is today a promise that binds the government and the judiciary. And one of the particular traits of our history is the tension between the government and the judiciary. We've had periods of our history when we've had extreme tensions between government and judiciary. There have been considerable tensions in the last 20 years. The judiciary have to remind our government from time to time that there are limits to executive power that have to be observed. I mentioned the method of development and the method of the common law as one of the originalities of the system a few minutes ago. And as we will see in quite some detail later, the system has developed essentially through cases decided by courts. Setting what we call binding precedents. And I'd like you to get that down, please. Binding precedents. And those binding precedents are set by decisions of the courts on specific fact situations. And this explains one of the differences between the English system and the French system. English lawyers tend to think about facts, first of all. We spend our time looking for previous cases that the courts decided in the same or similar fact situations. So that we don't really function like French lawyers who are taught to learn the civil code, to learn a set of principles, and then your analysis will really flow from a principle in the code. Obviously, you then go down and look at the jurisprudence and the cases to see how the courts have interpreted the principle. But we tend to start the other way around, you might say bottom up from the civil lawyer's point of view. We start with fact situations and then we sort of go further from there. One of the things that I tend to do is to tell you a story, which you don't necessarily have to note down, just to illustrate things, but we had a case in the office when I was in London, and the facts were a little bit complicated. Do a drawing so you can understand what I'm talking about. What you have to imagine is a joint venture. You know what a joint venture is? It's a société de fait. The two partners on the joint venture are a British company and a French company. The object of the joint venture was to exploit a mine in an African country, a uranium mine. It so happened that this African African country was a former British colony, so it had kept the common law system. No doubt, like a lot of African countries that kept the common law system, they then added their own customary law, like we did at the start, and then of course their own legislation and so on. If you look at South Africa is a very good example because it combines common law, Roman Dutch law, and South African customary law. And they built probably a very interesting legal system up there. Anyway, this wasn't South Africa, but it was a common law country. And what they did to operate the mine in this country was to create what we call a joint venture company, which was based in the African country where the mine was. And then it was agreed that each of the partners would contribute to the capital of this operation, like any business, and that they would be entitled to take out the product of the mine in their agreed proportions. Now, if I remember rightly, it was also agreed that each of the partners would pay a price for the uranium that it took out of the mine, and that price was a formula, mathematical formula, and part of the formula was the world market price, the world market price of uranium. If you exploit a mine, it goes on for a very long time, usually 20, 30 years, so we're talking about a very long-term joint venture of knowledge. After a few years, for various reasons, there was no longer a quoted world market price for uranium. You've all studied contract law, French contract law. So you know that in French contract law, when one of the essential elements of the contract disappears, yes, exactly. The contract can't exist anymore. As we say in English, it fails for uncertainty. So here we have a situation where one of the essential elements of the contract, you'll be doing contract law with next semester, one of the essential elements is gone. So the French party, for strategic reasons, said to the British party, sorry chaps, but the contract's finished. And so our joint venture is finished. We'll just have to wind it up and stop. In fact, I think they had strategic objectives. They probably wanted to take over the operation for themselves. So the law firm I was working for in London was instructed by the British party, and so my boss came to me one day and said, Wesley, find me a solution. To what is essentially quite a difficult problem legally. Because one other thing that I didn't tell you, which is quite important, is that the parties had not agreed which law would apply to the contract. But they had agreed that if there was a dispute, they would use ICC arbitration in Paris. You probably know about the International Chamber of Commerce in Paris, which provides an arbitration service, particularly for international contracts, to resolve disputes. And the decision of the arbitrators has the same force in most countries in the world as a judgment of the national. Anyway, so I went away to think about this and came back to see the boss the next morning, and he said, well, have you found a solution? And I said, well, not yet, but it's something to do with chickens. And he said, are you feeling all right this morning? What did you have to drink last night? So I said, no, I'm perfectly fine. But I'm sure there's a case about chickens that might help us solve this question. Because at that time we didn't have Google. So if you put chickens into Google, chickens in law, or chickens in precedence, you will probably find the case. But in our case, Nexus was just starting. So we put chickens in. And sure enough, out came on page 54 after 50 pages of European regulations on chickens. There was the case. The Sykes versus Farnborough. There was a Court of Appeal case. When I started the research, all I could remember was this thing about chickens. I couldn't remember the name of the case, I couldn't remember which court, and I couldn't remember which year. If you were better students than me, you would remember the name of the case. Anyway, so we got a copy of the case, and there it was. It said that if the parties have agreed an arbitration clause in the contract, and there's one problem with an essential element like the price or quantities, then the arbitrator has power to decide what is the right price or the right quantity. We then looked around all the Commonwealth countries in the world to see if the other court had decided the same thing. We looked at the States and Canada, Africa, all over. We couldn't find any other place. So it was just one precedent binding in England that said that an arbitrator had power to determine the essential element of the contract that failed for other reasons. So we knew that a decision of the Court of Appeal of England would be strongly influential in most other Commonwealth countries. And we thought that if the arbitrator had to decide the case, then the arbitrator would probably use the law applicable to the contract or the operations of the company, which were most closely linked with this African country. So it enabled us to go to the French parties and say, it's not quite as simple as you think, because we think the arbitrator will be strongly influenced by this decision of the Court of Appeal. So there we were, we started from chickens. So that's why I'm telling you that we don't really think that will probably come back again and again as we go forward. One of the other originalities of the system, I said, was the constitutional arrangements, which we'll look at in more detail. We'll start to look at it just after the break. The first point is that there is no written constitution in the sense of having all the important constitutional laws in one document, like France or the United States. We have never managed to organize that. What we do have a constitution, but it is in diverse legal sources. Common law, legislation, European law, European Convention of Human Rights now. And Also what we call conventions, which are really customs of the main institutions of state in the way they operate with each other. And those conventions regulate the interaction between those institutions. We will also look in some detail at what we call the rule of law, which I think is an expression you use in France as well, la règle de droit. And the rule of law has a particular emphasis in our constitutional setup, because it is there to protect fundamental rights and to ensure what the Americans call due process of law. We will see that the ordinary courts are engaged in constitutional and administrative law matters. And we will also see that European law and the European Convention have had a significant impact on our legal system over the last 40 years. The last originality that I mentioned was procedure. Our system of procedure is oral. Concretely, that means that disputed facts, because when cases get to a court, it's because there's a dispute, and very often the dispute is about the facts before you get to the legal questions. And in our system, if there is a disputed fact, it is proved by examination and cross-examination of the witnesses to the facts. So, examination and cross-examination of witnesses to the disputed facts. And the examination and cross-examination is done by the lawyers representing the parties. The judge may ask some questions, but will normally just be listening. The judge has to decide, first of all, whether a witness is credible, and secondly, whether the witness's memory or recollection of events is accurate or reliable. So there you have some key elements to our procedural system. Examination and cross-examination of the witnesses to the disputed facts by the lawyers, with the judge deciding whether the witness is credible and whether the witness's memory of the facts is reliable or accurate. This method, this procedure, is used both in civil and criminal cases. So, how many people have visited London? Or anywhere else in England? Okay. And how many have you actually been to a court? So some of you have seen perhaps this in action. You saw cross-examination in action. Yeah. And what did you think about that? Well, I think if you're on holiday in London, you may think the last thing you want to do is, if you're on holiday in London, is to spend an afternoon in a court. But it's all open, and as many people say, it's free theatre. If you go to the Central Criminal Court at the Old Bailey in London, as long as it's not during the judicial holidays, you can probably find a case going on where there's some examination and cross-examination of the witness. In a criminal case, it's, of course, the prosecution and the defense lawyers who are examining and cross-examining the witnesses, and the witnesses will include the police witnesses. And that is one of the reasons why our trials take a very long time. There was a case recently involving two Russian oligarchs who live in London, who had been in business together and then got engaged in a very big dispute. I think one of these oligarchs was in the witness box being cross-examined for a couple of weeks. So this is a very detailed procedure. I can tell you another story. We had another arbitration case in the office in London where there was expert evidence, and it was all about a gas tank containing liquefied natural gas somewhere in the Middle East that had exploded because there was a crack in the tank. And our clients had built it. So the owner of the gas plant commenced an arbitration against our clients because they claimed that our clients were responsible for the millions of dollars of damage that had been caused by the explosion of this gas tank following the escape of the gas through the crack. And what you have to imagine is what a gas tank looks like. It's made up of lots of metal plates. The metal plates are welded together, sooty. And what had happened was that one of the welds had cracked, a microscopic crack, and gas started to escape and then exploded. And so the question that had to be answered was, why did this crack appear in this tank? And the only way it could be explained was by experts in metallurgical science. So that the two key witnesses for this case were two professors of metallurgy from the UK. They were called to give evidence. One for the owner of the gas plant and the other for the fire. The way the expert evidence works in the English system is that what happens is the expert will produce a report, and then be given to the other party and their lawyers, and then the expert will be called as a witness, will go into the witness box, and then will be examined and cross-examined. So what you have to imagine is that the professor of metallurgy who had written the report for the owner of the gas plant sent this report to us, and we asked our professor of metallurgy to have a look at it and tell us what he thought. It's a pretty thick document full of mathematical calculations, photographs of the piece of they managed to reconstitute the tank. To find the piece of weld that cracked, and some microscopic photographs. And our professor said to us, that's all very interesting, but it's a bit strange because I don't think the other professor had written the report. He's a very busy man. And he's probably given it to one of his assistants to write the report and do the calculations. And then the professor has probably obviously read it through, given it his okay, and then signed it. So you may know that in England we have two professions. We have solicitors, and then we have barristers. And barristers are people with wigs and gowns who are specialists in pleading, and lots of them specialised in cross-examination of witnesses. It's a skill. So the barrister said to this professor, to our professor, said, well, are you absolutely sure that the other professor hadn't written this report? And our professor said, well, I'm 95% sure. So the day comes when the other professor is put in the witness box, examined by the owner of the gas plant, and then cross-examination. So our barrister stands up and says to the professor, good morning, you're Professor Smith from the University of Wales, specialist in metallurgy. Is that correct, Professor Smith? Yes. Professor Smith, you've come here to give evidence today on this report. Is that correct, Professor Smith? Yes. Professor Smith, can you tell the tribunal whether you wrote this report yourself? Professor Smith? We've obviously overlooked it, Professor Smith, because it's kind of changed colour. Gone a bit red. Started this way. Professor Smith, can you answer the question? Did you write this report that you've come here to give evidence today? Not all of it. Does that mean, Professor Smith, that you have come here today to give evidence to this tribunal about a report that you haven't written? Is that correct, Professor Smith? Thank you very much. Finished. Finished as a witness. You can't be credible. How can you be credible to give evidence about a report that you have written? So they didn't even get past the first stage of the cross-examination, credibility of the witness. After that, obviously you then go into the details, technical details, to see whether the evidence itself was reliable. But they were already practically out of court on the credibility issue. And this is something that you will find everywhere in the common law system. This is the way it works. In the United States, you've all seen films of Harry Mason, Lucia has been seen in the courtroom, prosecution. It's a key part of our system. So maybe we stop just for 10 minutes, and then we pick it up again. If you have any questions, because I know some of you are shy,